We talked about some of the mistakes, and one of the mistakes involves the way retirement plan accounts work or are dealt with at the death of the account owner. The Secure Act, which was effective January 1, 2020, changed a lot of the rules that affect the way beneficiaries are taxed on the retirement account when the owner dies. When I refer to retirement plan accounts, I'm talking about 401k plans and IRAs and 403b plans and similar plans that are funded with pre-tax dollars. That means when the money goes into the retirement account, you're not subjected to income tax on that money. That's because you're entitled to a tax deduction as funds go into the account. But when you withdraw from the retirement account, what you withdraw is included in your taxable income and is subject to income tax at that time. These retirement accounts are meant for your retirement, so if you withdraw from them too early, that means before you're age 59 and a half, you must pay a penalty. Not only must you pay an income tax on the early withdrawal, but you must also pay a penalty on the early withdrawal unless the withdrawal qualifies for certain exceptions. One of those exceptions is the death benefit. Also, since the retirement account funds are intended for retirement, there are rules that say that you must start withdrawing from the retirement account around the time of retirement. You can't just keep your money in that retirement account indefinitely and have it earning income in a tax-favored, tax-deferred environment. There are minimum required distribution rules. The Secure Act changes the minimum required distribution rules. Before the Act, minimum distributions were required at age 70 and a half. Effective on January 1, 2020, minimum required distributions must start after age 72. So, if you turn age 72 on or after January 1, 2020, your first required minimum distribution would be for the calendar year after the year in which you turn age 72. When the account owner dies and the beneficiaries are entitled to the balance in the account, in most cases, under the new law effective January 1, 2020, a beneficiary who is not a surviving spouse must withdraw the full balance of the retirement account within 10 years after the account owner's death. I'll get into the rules that apply in that case in more detail in Part 8 of this video series. If the owner's spouse is the beneficiary, the spouse may roll over the full account balance and make that account her own without paying tax as long as the funds remain in the account or in the rollover account. In that case, the spouse can wait until she is age 72 before she must start withdrawing from the account. I want to show you an example of some of the problems these types of accounts can create. Here's an example of a client whose estate is more than the estate tax exemption that's available at his death, whatever that exemption happens to be at the time. Assume that all his assets are illiquid, perhaps all in real estate and in a business with partners. In 2016, his IRA had a value of $1,445,000, and it grows to $2,355,000 when he dies in 2026. The total estate tax would depend on the state in which the client resides, but let's assume that the state estate tax and the federal estate tax will be around $609,000. The question is how that $609,000 in taxes is going to be paid. Remember, we've assumed that this client's non-IRA assets are illiquid, that they cannot easily be converted to cash. There may be a temptation to go in and withdraw that $609,000 from the IRA to pay the estate tax, but keep in mind that any withdrawal from the IRA will be subject to an income tax, so this is the unfortunate result. Here you see that there's a withdrawal made of $609,000 to pay the estate tax, but now there's an income tax on that withdrawal. Let's assume, for the purposes of this illustration, that the income tax is approximately $209,000. So the beneficiary is sitting there, scratching his head, and says, how am I going to come up with that $209,000 to pay the income tax? There's only one source for it, so he goes in and withdraws another $209,000 from the IRA and creates a new income tax obligation of $72,000. So he goes in and withdraws another $72,000 to pay the income tax, and now he has a new income tax of $25,000. So you can see what's happening. Every time he makes a withdrawal to pay the income tax, he has a new income tax to pay. So by the time it's over, not only has he had to pay the $609,000 estate tax, on top of that, he has to pay $319,000 in income tax, a total tax bill of $928,000. Part of estate planning is to try to avoid that unfortunate result and to protect that IRA from the estate tax burden. There are several ways to do that. One way to do that, and there are many ways. For example, one way is to include provisions in your will that direct which assets bear the burden of the tax. So typically, our wills will direct the burden away from the IRAs. Here's something else that can be done for a client with a cash-poor estate. For example, maybe the client has a large IRA and real estate investments. The question for this client is, where's the cash going to come from to pay the estate tax? As we said before, real estate isn't very liquid, and we saw the problems that you get into when you try to use the IRA as a source of cash to pay the estate tax. So, lots of times, to protect the IRA, the client will consider purchasing life insurance, and the life insurance is purchased in a way so that it will not generate an estate tax. Remember what I previously said about life insurance. If you're the insured and you're the owner, then the life insurance death benefit is included in your estate when you pass away. But if you're not the owner, it won't be included in your estate. So often the solution is to acquire life insurance, but when you do so, to make certain that the insured is not the owner. Instead, a trust called an irrevocable life insurance trust can be the owner. That's a very common plan. In that case, the trust owns the life insurance policy and receives the death benefit, and then the death benefit can be used to make a loan to the estate to pay the estate tax. In the next segment, we'll talk about income tax issues related to retirement plan benefits.